the red folder that you pulled out?
That's not public information.
Okay, so what's contained in the red folder?
It's not public information.
Alright, so you don't even know what's contained in it?
It's not public information.
Not public information.
That's interesting.
Alright, let's start with number 1.
Not public information. So it's secret then.
Something like that. Yeah, I never got a copy of this order though. I got the other orders that were issued on the 12th.
Looks like a copy of the $1 per page.
Okay, well, since I was never served a copy, I'll do is I'll just file a
Are
motion.
you Mark Adams?
Mhm.
Yeah, you were served a copy.
No, it wasn't.
The one in the mail, you might not have received it. The mail might have had problems, but you were served a copy.
I received this one,
Okay.
and I received this one, also served on the same day.
Right.
Both in the same envelope.
Well, if
Received
you'd
that.
like a copy, it's $1 per page, and we'd be glad to make you a copy.
I received that.
Okay.
And I had a witness when I opened the envelope.
Okay, well, if you'd like a copy, it's $1 per page.
And I'm just go ahead and file a motion saying that it wasn't served, because it wasn't served.
Are you down with all this?
Yeah.
All right.
Okay, also I noticed that none of the orders were signed by any of the judges. What's the deal with that?
So if you have any questions, you can put your concerns in writing.
And also I noticed that none of the orders that were signed by the clerk, there were no authorizations contained in the file for any of the orders. No authorizations by the judges for any of the orders that were signed by the clerk. Or were the authorizations for those
Any
orders?
concerns you have, you may put in writing.
Okay, so you're not saying anything. Have you been instructed not to answer any questions?
No, sir. Just anything that's just to know that's how we handle everything.
Okay, so that's just a standard operating
Yes,
procedure.
sir.
Do you have an employee manual or anything available for review?
I mean, that's something to check with personnel with if you'd like.
I'm talking about something that says not to answer any questions.
Right, it's not that we can't answer any questions, but you can check with personnel for that if you'd like.
Okay, so is there a document that tells everybody not to answer any questions concerning judges signing orders, or is there not a document?
Certain stuff is not public information, and certain stuff is. So, but if you have any concerns, you can put in writing and start going over it.
Okay, so if I make a public records request right now for the internal operating procedure that says that you all aren't supposed to answer questions, such as what judges authorize a particular order.
And what the judge assigned you is not public information. What's on the order, what you see is what's public information. There's a judge's name on it, that's public information. There's a side that's public information, what's on there.
There's no signature by a judge on anything, by any of the justices, I mean.
If you said it says the judge, the file has to go before the justices. The clerk can ultimately make decisions on things as well.
Oh, so the clerk can make decisions without the justices' approval?
The clerk can make decisions on things, yes, sir.
Well,
That's laughable.
Well, the Constitution says no, it can't.
If you said it says the judge, the file has to go before the justices. The clerk can ultimately make decisions on things as well.
Oh, so the clerk can make decisions without the justices' approval?
The clerk can make decisions on things, yes, sir.
Well, that's
laughable.
Well, the Constitution says no, it can't do that.
What's the qualifications of the clerk?
Any concerns you guys have, you may put in writing.
Okay, well, that's
The
what
clerk
we'll
is
do.
an appointed position, isn't it?
Right, totally
so-
appointed.
Okay.
Actually, the clerk is hired just like anyone else.
Well, okay, so they're hired. But what are the I'd like to see what the job description, and the job description and the qualifications to be a clerk of the Supreme Court of the state of Florida is.
Me
Right?
too. And
I mean, 'cause
unlimited
that's just like
discretion.
laughable. Because if it's supposed to go before the justices to, you know, for their review and decision, how can the clerk make the decision?
I know.
It just doesn't
Is he
conform.
getting ready to film you?
No.
So here's the Supreme Court of Florida, Thursday, July 12th, Florida Bar versus Mark A. Adams. And we scroll down the order. Not a single justice's name. There's Gregory P. Holder's name, and Andrew Blaze Sasso, John Kiernan, Kenneth Lawrence Marvin, Jody Anderson Thompson, and Mark A. Adams. Once again, going back up the order. No justices' names on the order. Interesting. Here's another order entered by the Florida Supreme Court on Thursday, July 12, 2007. It's the Florida Bar, once again, against Michael Gaines. Scrolling down the order. Oh, what is this? The names of justices are listed on the order who have concurred in the decision. Okay. And the names of justices who concurred in this decision are Lewis, Chief Judge, that's CJ, and Wells, Anstead, Pariente, Quince, Quintero, and Bell. Concur. And once again, that's issued on Thursday, July 12, 2007, in the Florida Supreme Court. Well, let's just say, let's look at another one. Supreme Court of Florida, Monday, July 2nd, 2007. Florida Bar versus Alberto somebody. And it's a petition for emergency suspension. It's approved. The bar tried that with me too, except they didn't have any grounds to suspend me on an emergency basis, and they completely failed to comply with the requirements for filing a petition for emergency suspension. So I won that one. But once again, the names of the justices who concur in issuing this order are listed on it. Once again, Chief Judge Lewis, Chief Justice Lewis, Wells, Anstead, Pariente, Quince, Quintero, and Bell. Interesting. And yeah, that's Monday, July 2nd, 2007. Here's one on Wednesday, July 11th, 2007. Supreme Court of Florida, Florida Bar versus Henry John Martosi. Oh, once again, the names of the justices who concur are listed on the order. Interesting. Alright, here's another one. In the Supreme Court of Florida, Tuesday, July 17th, 2007. The Florida Bar versus Charles Beam. Let's see if the justices' names are on this order. Oh, yes they are. Oh, and there's a dissenter this time. This time it's Chief Justice Lewis, Wells, Anstead, Pariente, Quince, and Bell who concur, and Justice Quintero dissents. Interesting. Very interesting. Once again, that's a Florida bar proceeding in the Supreme Court of Florida with an order entered on Tuesday, July 17th, 2007. Well, let's check this one out. Here's an order entered in the Supreme Court of Florida on Wednesday, July 11th, 2007. The Florida Bar versus Alfonso Salcinas. Here we find that the report of the referee found Alfonso Salcinas not guilty of any alleged rule violations and imposing no discipline. Alfonso Salcinas is E.J. Salcinas' son. E.J. Salcinas is a former justice or judge on Florida's 2nd District Court of Appeal, one who was involved in the rearranged a panel that denied my petition for a writ of prohibition, throwing Judge Crockett Farnell off my case, after the initial panel, who was assigned to hear my petition, directed the clerk to issue an order to show cause to Judge Crockett Farnell. Of course, there was no paperwork explaining the reassignment, and the court refused to explain their decision, which was once again contrary to the first panel's decision. And of course, Florida's Constitution doesn't allow for 2 different panels to consider a case. It says 1 panel of 3 judges shall consider each case in Florida's District Courts of Appeal, and the concurrence of 2 judges are necessary to decision. But back to the Florida Supreme Court. Here we see that Judge Bernard Shapiro was the referee. And once again, the Supreme Court on Wednesday, July 11, 2007 finds Alfonso Salcinas not guilty of any alleged rule violations, just like the referee said. Now, interestingly, Justice Quince dissents from this. Okay, here's another one, issued in the Supreme Court of Florida on Wednesday, July 18, 2007. The Florida Bar versus David Stahl. Ooh, once again, all the justices' names are listed on the order. Here's another one, issued in the Supreme Court of Florida on Tuesday, July 17, 2007. The Florida Bar versus Rose Spano. Okay. Oh, once again, all the justices' names are listed. And in this case, Justice Anstead dissents from the decision. Let's go back to my special case. Supreme Court of Florida, the order issued on Thursday, July 12, 2007, disbarring me permanently, has no justices' names listed on it. Not a one. Not a single one. It is void on its face because it does not comply with Florida's Constitution, which requires at least 4 of the 7 justices concur in a decision. Here, once again, we have none. And of course, like the deputy clerk said, the clerk just enters decisions sometimes without any justice. Now, is that justice? I don't think so. That's Florida style, third world justice. Welcome to America. Hal Bushler. I just want to touch on this motion for rehearing, order denying that. Once again, that's entered on Wednesday, July 18th. Florida Bar versus David Stahl. Mr. Stahl had moved for rehearing. The court denied it, and all the justices' names who concurred are listed on the order. And here's the Supreme Court of Florida, Thursday, November 15th, 2007, the Florida Bar versus Mark Adams. This order says the respondent's motion for rehearing filed with this court on August 9, 2007 as respondent's verified motion to vacate order entered on July 12, 2007, disbarring the respondent, is hereby stricken as untimely. And once again, not a single justice's name listed on the order. I feel special. Now let's look at the Florida Bar News from November 15, 2007. Amazingly, they printed that I had been permanently disbarred on the very day that the court issued its decision. Now, what we're seeing here is an online PDF copy of it, but this is a newspaper style publication that goes out every 2 weeks. And I'm listed on there, and here we go. The next person is a September 10 order. The person after that is a September 27 order. A September 20 order. A September 20 order. A September 10 order. September 6 order. September 6 order. September 18th order, September 27 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 order, September 10 order, September 27 order, September 12 order, September 11 order, September 20 order, September 4 order, and September 6 order. But me, my order, it doesn't mention that it was just entered on November 15th, and yet published in the Florida Bar News the very same day that the order was entered. And of course, going back to the July 12th order. Now, why did they wait from July to November when all the rest of them were from September and October, published in November? I feel special. Once again, another look at my order denying my motion for rehearing is untimely. November 15th, 2007. And amazingly printed in the Bar News that very same day. Amazing Florida Bar News. It's like they can see into the future.